Hello and welcome to LiveLaw Daily. I'm your host Debojit Das, and today, the 24th of July, is important because of a lot of reasons, but one among many is because it's Income Tax Day. It's on this day that the income tax was introduced in India back in 1860. Moving on to today's top stories, which makes this day a lot more significant. So let's get into it. We begin today with a significant development in the Supreme Court's continuing oversight of the Manipur violence cases. More than 2 years after ethnic clashes engulfed the state, the court has signaled that it may now push these cases into a faster trial phase. A bench comprising Chief Justice of India Suryakant, Justice Joy Mallya Bagchi, and Justice V. Mohana was reviewing status reports filed by the CBI, various special investigation teams, and a former Maharashtra DGP too, who has been appointed by the court to monitor the investigations. The court noted that while the CBI has filed charge sheets in 21 cases, investigations are still pending in several others. Across Manipur, special investigation teams are investigating over 3,000 cases, but charge sheets have been filed only in 301, and trials have begun in just 10. The reports also indicate that nearly 2,900 witnesses are proposed to be examined. And the CBI informed the bench that the investigations have been slowed by several practical difficulties, including displaced witnesses, lack of cooperation arising from mistrust, language barriers, and the challenge of collecting digital evidence after prolonged internet shutdowns. While acknowledging those challenges, the Supreme Court made it clear that investigations cannot continue indefinitely. The bench observed that all pending probes must be completed within a reasonable time and proposed the constitution of special courts in consultation with the governments and the high courts of Manipur and Guwahati so that trials can proceed on a day-to-day basis. The court also directed that victims' families who are yet to receive copies of charge sheets must be supplied those documents within 1 week after approaching the legal aid mechanism. On the issue of religious structures damaged during the violence, the court permitted affected groups to place details before the court-appointed committee, directed that no further encroachments be allowed, and extended the committee's tenure till December. Our second story concerns the future of India's biggest entrance examinations. The Supreme Court has made it clear that recurring paper leaks and temporary fixes to examination security are no longer acceptable, saying the system must undergo permanent institutional reform. A bench of Justice P.S. Narasimha and Justice Alok Aradhe was hearing petitions filed after the cancellation of the NEET UG 2026 examination due to a paper leak. The union government sought time, informing the court that it is finalizing reforms that could go beyond the recommendations of the high-level committee headed by former ISRO chairman Dr. K. Radhakrishnan. While granting time till August 3rd, the court made it clear that it intends to monitor closely the reform process. Justice Narasimha said that the focus is not merely on responding to latest crisis, but on ensuring complete institutionalization of the National Testing Agency so that the same problems do not recur. The bench directed the centre to file a comprehensive affidavit explaining the progress made in implementing the committee's recommendations on the NTA's governance structure, recruitment of domain experts, appointments to specialized divisions, and measures to improve transparency and accountability. The court sought details on the proposed shift from pen and paper examinations to computer-based testing, including safeguards for data security, encryption of question papers, secure transfer protocols, and stronger candidate verification systems. Observing that ad hocism has troubled us the most, Justice Narasimha said the court would follow the reform process throughout the year, adding that we cannot let this go on like this. The matter will now be taken on August 3rd. And our third story brings two separate proceedings before the Delhi High Court arising out of the recent NEET student protests, but raising two very different legal questions. The first was a public interest litigation seeking an NIA investigation into the July 20th Sansad Chalo protest. The petitioner alleged that what began as a student demonstration had turned into a politically bagged agitation involving various leaders and acts of vandalism. However, a bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya declined to entertain the plea. The court pointed out that the National Investigation Agency is an investigating agency, not an inquiry body, and that under the NIA Act, An FIR must be first registered before the statutory process for an NIA probe can even begin. When the petitioner argued that the court itself could direct an NIA investigation, the Chief Justice responded that forming such an opinion is the responsibility of the central government, not the court. The bench also refused to call for a police status report, observing that FIRs had already been registered and the authorities were expected to take the investigation forward in accordance with law. It similarly declined the request for a CBI probe, noting that such a stage has not yet arisen. The second matter concerned a public interest litigation filed by former JNU Students' Union President Aishe Ghosh, alleging continuous police surveillance of protesters at Jantar Mantar through videography and facial recognition technology. Appearing for Ghosh, Senior Advocate Nandita Rao relied on the Supreme Court's Puttaswamy privacy judgment to argue that citizens do not surrender their right to privacy merely because they are protesting in a public place. She expressed concern that the use of live facial recognition could result in innocent people being wrongly identified and dragged into criminal proceedings. Urging the court to lay down safeguards, Rao submitted that even private conversations among protesters were being recorded, warning that such footage could later be selectively edited and used in criminal cases. Solicitor General Tushar Mehta, appearing for the Delhi police, opposed the plea, arguing that videography is a standard law and order measure adopted at public protests across the country. He questioned how a person demonstrating in a public place could claim a complete expectation of privacy, particularly when many protesters themselves were recording videos and broadcasting them on social media. After hearing both sides, the division bench did not pass any interim directions and listed the surveillance challenge on further hearing on July 27th. Our fourth story concerns the Supreme Court's attempt to regulate how courtroom proceedings are shared online. In an interim order passed today, the court prohibited the extraction, editing, uploading, reposting, dissemination, or monetization of audio and video recordings of court proceedings on social media and digital platforms without prior permission from the Registrar General of the concerned High Court or the Secretary General of the Supreme Court. The order came on a petition filed by journalist Harshita Grover, who argued that selective out-of-context courtroom clips are increasingly being circulated with sensational captions, distorting judicial proceedings and undermining public confidence in the justice system. Importantly, the court clarified that this restriction does not affect fair news reporting of court proceedings. During the hearing, Justice Joy Malia Bagchi remarked that while live streaming promotes transparency, it should remain an exception rather than a norm, adding that courts cannot become a 24/7 entertainment channel. Solicitor General Tushar Mehta also flagged the growing threat posed by artificial intelligence, warning that deepfake technology can now alter spoken words while perfectly matching a person's facial expressions and lip movements. The Chief Justice echoed those concerns, recalling instances where remarks were attributed to him that he had never made and observing that even the print media had, at times, put words into his mouth. The court also took note of earlier instances where edited courtroom videos had to be removed, including a Delhi High Court case involving selectively cropping recordings. It issued notice to the union government, all high courts and major social media platforms including Meta and X, while asking the centre to identify the nodal ministries that would implement any future regulatory framework. The high courts have also been asked to submit reports on the implementation of the Supreme Court's live streaming guidelines and the impact of continuous live streaming of proceedings. Continuing with examination-related developments, the Bombay High Court has designated 2 special courts to exclusively handle paper leak cases. The move comes a day after the central government announced the setting up of fast-track courts across the country to deal with offences under the Public Examinations Prevention of Unfair Means Act of 2024. Acting Chief Justice Ravindra Ghugge has designated 1 special court each in Aurangabad and Nagpur to be presided over by Justice S.V. Pawar and Gulshan Kolte. The centre had requested high courts to identify special courts and appoint experienced judicial officers to try offences under the 2024 Act, as well as the Bharatiya Nyaya Sanhita. The Act itself envisages speedy trials, requiring such cases to be concluded as far as possible within 3 months. The Bombay High Court's decision follows a similar move by the Delhi High Court, which has already designated a special fast-track court at Rouse Avenue to hear criminal cases arising out of paper leaks and other examination malpractices. And our sixth story today comes from the Kerala High Court, which has expressed concern over conflicting official figures relating to pending criminal cases against sitting and former members of parliament and members of the Legislative Assembly. A division bench of Chief Justice Somen Sen and Justice Shyam Kumar VM was hearing a suo motu matter monitoring such cases in compliance with the Supreme Court's directions in the Ashwini Kumar Upadhyay case. The court found a significant mismatch between the data submitted by the High Court administration and the state police chief. While the High Court's report recorded 555 criminal pending cases against sitting and former legislators as of June 30th, the state police chief's report reflected only 256 cases based on data from earlier that month. The bench also noted delays in executing court processes. According to reports from the district judiciary, 12 cases pending for more than 5 years and 31 cases older than 2 years are still awaiting execution of summons or warrants. Observing that these details had already been shared with the police authorities, the court directed that the reports be forwarded to the special government pleader so the state police chief could exercise greater diligence while filing future status reports. It also directed the Assistant Inspector General of Police to file a comprehensive report regarding the large number of unexecuted warrants in Thiruvananthapuram city. The matter will now be taken up on August 13th. And our seventh story today comes from the Punjab and Haryana High Court, which has strongly criticized the Haryana government while directing it to grant compassionate appointment to the son of an army brigadier who died during Operation Snow Leopard in Ladakh. The case concerned Brigadier Abhimanyu Singh Rathore, who developed cerebral venous thrombosis or CVT while serving in the high altitude operational area during the Galwan standoff with China. He later died during treatment and the army officially classified his death as a battle casualty under Army Order 5 of 2020. However, the Haryana government rejected his son's claim for compassionate appointment, contending that the officer had died of a disease and was therefore not covered under the state's policy. Justice Nidhi Gupta rejected that stand in emphatic terms. The court observed that if the officer had not been posted in a high-altitude operational zone, he would, in all likelihood, not have suffered the condition. Referring to the medical impact of low oxygen levels and dehydration at high altitude levels, the court described the state's attempt to treat the death as an ordinary disease as preposterous, crass, and ignorant. The court further clarified that the state's policy is not confined only to so-called martyrs. It pointed out that subsequent government policies expressly include battle casualties, and that once the army had certified Brigadier Rathore's death as a battle casualty, the state could not disregard that classification. Accordingly, the High Court allowed the petition and directed the Haryana government to grant compassionate appointment to Brigadier Rathore's son under the applicable policy. And our eighth story comes from the Delhi High Court, which has refused to grant interim relief to news agency ANI in its copyright infringement suit against OpenAI, the company behind ChatGPT. The lawsuit filed in 2024 is the first in India against ChatGPT. ANI alleges that OpenAI commercially exploits its copyrighted news reports, that ChatGPT reproduces portions of its content verbatim, and that the chatbot has at times attributed fabricated statements to ANI through so-called hallucinations, harming the agency's credibility. However, while deciding ANI's application for interim relief, Justice Amit Bansal held that OpenAI had made out a stronger case at this stage. The court observed that merely storing ANI's works for training purposes does not by itself amount to copyright infringement, especially when the outputs generated by ChatGPT are not substantially similar to ANI's original reports. The court further found that ANI had failed to establish a prima facie case that ChatGPT was memorizing and reproducing its copyrighted content. It held that granting an interim injunction at this stage would cause irreparable prejudice not only to OpenAI, but also to the public at large. OpenAI has consistently argued that its AI models use copyrighted material in a transformative manner, that facts contained in news reports are not themselves protected by copyright, and that publishers who do not wish their content to be crawled can opt out. With these findings, the Delhi High Court dismissed ANI's application for interim injunction. The copyright suit itself, however, will continue and be decided on its merits. And finally today, the Delhi High Court has sought the Election Commission of India's response to a public interest litigation challenging the large-scale deployment of government school teachers for the ongoing special intensive revision of electoral rolls in the national capital. The public interest litigation argues that assigning teachers as booth-level officers and enumeration staff has severely disrupted classroom teaching, with many government schools reportedly relying on guest teachers or teachers from unrelated subjects, while private schools continue functioning normally. During the hearing, a division bench of Chief Justice D.K. Upadhyay and Justice Tejas Karya questioned the extent of the Election Commission's powers, asking whether it could do whatever it likes under Article 324 of the Constitution. Appearing for the Election Commission, Advocate Sanjay Vashisht submitted that following representations, teachers have now been asked to perform revision-related duties only after school hours or on holidays, so that classroom teaching is not affected. He also informed the court that the exercise is almost complete and every effort has been made to minimize the disruption to schools. The petition, however, seeks broader directions, including limiting deployment to no more than 10% of the teaching staff in any school, scheduling election duties outside teaching hours, and using non-teaching personnel wherever possible. The High Court has directed the Election Commission to file a short affidavit by Monday and will hear the matter again on Tuesday. And that wraps up today's edition of LiveLaw Daily. If you'd like to explore any of these stories in greater detail, you'll find links to our complete reports in the description below. For comprehensive coverage of the Supreme Court, the High Courts, and legal developments across the country, keep following livelaw.in. We'll be back tomorrow with more.